What's your takeaway?
I think the case is a travesty. First of all, Wade Robson was my first witness in Michael Jackson's criminal trial. And I had to think long and hard about whether we even needed to put on a defense case because the cross-examination of prosecution witnesses went very well. But I decided to put on a case, and when you do that, you want to start strong and you want to end strong. I started with one of my strongest witnesses for Michael Jackson, Wade Robson. He was adamant that he had never been touched, never been molested, never been abused, directly or indirectly. I called his mother and sister as witnesses to corroborate what he said, because they traveled on these tours too. And to have him suddenly reverse course so radically years after Michael Jackson has passed away and can't speak up for himself is outrageous. So I don't think he has a case. I think this is a money grab, like so much of Michael Jackson's unfortunate life. Everybody seemed to have their hand out in one way or another. And I just think it's ridiculous. Safe Chuck I put in the same category. He didn't testify in the criminal trial, but he signed declarations. As I recall, he signed declarations, made statements that he had never been touched. Now,
and these are declarations under oath.
That's my understanding. I haven't seen.
But Wade Robson did swear under oath.
Wade Robson, I put him on as my witness,
right.
And he was subjected to a withering cross-examination by Prosecutor Ron Zonin from the Santa Barbara District Attorney's Office. I mean, Ron went after him, and Ron's a good prosecutor. He would not waver. He was adamant he was never touched. And my understanding was Safe Chuck repeatedly said the same thing. So to suddenly come back years later and say we want millions of dollars, we were brainwashed, we had repressed memory, we didn't face the facts, we didn't deal with reality, I just find very, very suspicious. And also these leaks about Michael so-called paying off $200 million to other so-called victims. First of all, the timing is curious. They were leaked or at least given to the media right before the hearing was scheduled to take place. It's been continued now till May. And so that's curious. That reminds me of attorney Larry Feldman's playbook in the early 90s when he represented someone named Chandler who sued Michael Jackson, and Michael was represented by Howard Weitzman, who represents the estate now, and Howard signed a settlement agreement where he reportedly paid close to $20 million. It was a confidential agreement, but that then got leaked, and it ended up coming into the criminal courtroom when I was defending Michael. Not the amount. The amount was not allowed to go before the jury, but the fact that he settled was. Howard Weitzman represented Michael Jackson in that case. He settled that case for a reported $20 million. He signed the settlement agreement. He appeared at the press conference to announce it. And I don't think it's a good idea that he's the lead counsel defending these cases, because I think it sends a message that the estate might settle. But nevertheless, Larry Feldman, the plaintiff's lawyer in that case, was periodically leaking damaging information out, disturbing information out, and then there'd be silence, and then he would leak it out again. And I think these plaintiff's lawyers in the Robson Safe Chuck case are borrowing from his playbook. They're putting pressure on Mr. Branca and Mr. Weitzman to think carefully about whether they want this thing to continue.
Hasn't Mr. Weitzman claimed that he didn't settle that lawsuit?
He's claimed he was against it, but his signature is right on the document. You can find it on the internet, and he was at the press conference to announce the settlement. So I don't believe for a second he was against it, but he says he was. Let people be the judge of his behavior. But I think having him as lead counsel is a tremendous mistake, and I think it sends the wrong message. I hope these cases get thrown out. I think they're bogus.
Do you think it's all right to actually bring, I mean, is there an issue in terms of bringing a lawsuit for sexual abuse after somebody has passed?
I think it's very troubling, because the person who's passed is not there to give their position, is not there to say this is silly, is not there to cooperate with the defense lawyers. There's something very wrong about it, but my understanding is under the law you can sue an estate for a valid claim. Now the defense is claiming it's filed too late. Apparently, technically, they have been filed too late, but as we saw in the Catholic Church sexual abuse cases, judges will make exceptions for people who claim repressed memory, that they were in denial, that they suffered the normal effects.
Apparently that's quite common with sexual abuse, that there is science to, and anecdotal evidence as well, that when somebody has been sexually abused, that sometimes it takes them 30 years to come forward and whatnot. But we were discussing this before, and in terms of the Catholic Church, those allegations are also being made against the Catholic Church for their actual behavior. The state in this instance didn't do anything proactive to move, and to hide. At least they are not even being charged with that. That's not the allegation. So we have a bit of a difference here when you're suing the Catholic Church over molestation. Priests that they were in charge of, priests that they moved around, priests that they were aware of were abusing people isn't quite the same thing as suing somebody's estate, because basically in the case of Michael Jackson, you're suing Michael Jackson. not as a state,
You know,
I'm for
not,
his behavior.
I'm not in that case. I don't know a lot of the details. I think they tried to sue his corporation as well. But nevertheless, I think the case is a travesty. If it's not thrown out, however, I don't believe Mr. Brank or Mr. Weitzman have the guts to try it. I don't think we're going to see these witnesses going into court in a public forum giving this type of salacious testimony, the kind of testimony I had to deal with in the criminal case. I don't think they have the guts to try it.
Is it a question not of guts, but rather of protecting the entity of the estate so that, that it's not harmed by yet another trial?
Well, the problem is that if you settle it, you're not only inviting other people to make similar claims, unfortunately, it sends a message that perhaps Michael Jackson did this kind of thing. Now, when I got involved in Michael Jackson's criminal case, I had a jury consultant do some surveys of attitudes in northern Santa Barbara County where I had never tried a case before. And those surveys showed that the one thing that disturbed people the most, whether they appeared to be pro-prosecution or pro-defense, was the fact that he had paid millions of dollars to settle cases. So if the word gets out that the estate paid millions of dollars to resolve these cases, it will have a damaging effect. But the estate might decide that the damaging effects of that are not as severe as seeing these witnesses testify one after another to salacious testimony, even if they're lying.